in your organization?
Absolutely. Good afternoon. I'm Sarah Hunt-Blackwell. I'm Senior Policy Counsel at the ACLU of Georgia. I'm thankful to be here this afternoon and for this discussion. I'm here testifying in opposition to Senate Bill 443 because it expands criminal liability for First Amendment protected protest activity. So protests can come about in a number of ways. Some are pre-planned, with organizers submitting permit requests and road closures well in advance of the protest itself. Some come together more spontaneously in response to current events. And we know that the pre-planned protests receive First Amendment protection, but the United States Supreme Court has made clear that spontaneous demonstrations are also protected by the First Amendment. So this means that people can literally take to the streets without the formality of requesting permits and road closures within a certain time frame after a newsworthy event occurs. So SB 443 undermines the First Amendment protest protection by discouraging people from protesting newsworthy events in public roadways due to the possibility of arrest, prosecution, and imprisonment. So this bill also imposes concerning penalty enhancements and mandatory minimums. No harm or injury whatsoever is required in order for someone to be charged with a high and aggravated misdemeanor under this bill. This is the same criminal liability that is applied to people who are charged with battery against a pregnant person, reckless driving, or a third conviction of DUI. Merely obstructing a roadway pales in comparison to these crimes. In that same vein, a mandatory minimum felony charge for any type of bodily injury or property damage, I think kind of to Senator Watson's point, is also extremely concerning. Felonies in Georgia usually apply to violent crimes and other offenses that result in extremely severe outcomes. As written, someone could face at least 5 years in jail, pay at least $5,000 in fines, be stripped of their voter status, experience difficulty gaining employment and housing, among other consequences, if their road obstruction causes injuries or property damage, no matter how minor. Quite frankly, the punishment doesn't really fit the crime. Multiple sections throughout Georgia Code already establishes penalties for the conduct that this bill seeks to address, and there's no need to increase the criminal liability or impose a mandatory felony charge for conduct that may not even result in any real harm. For these reasons, we respectfully ask the subcommittee to vote no on SB 443, or at the very least to reconsider the language and consider amendments that balance the liability of the offense. Thank you for your time and consideration. I yield for any questions.